for strangling him.
I was having fun with that.
It's a gruesome trial that captivated Law and Crime Network's audience as Wisconsin woman Taylor Schabusiness is convicted of murdering, dismembering, and sexually assaulting her lover.
But when did you start, cutting up his body?
I don't know, like almost right away. I was sucking and cutting at the same time.
Officials in Green Bay, Wisconsin say Schabusiness knowingly killed her lover, 24-year-old Shad Thyrion, in February 2022. At trial, jurors heard evidence that Schabusiness choked Thyrion to death with a metal dog collar in what started off as kinky sex. After Thyrion was dead, Schabusiness dismembered his body and sexually assaulted the corpse. After her arrest on February 23, 2022, she admitted these disturbing details to police.
And you said that she played with his penis
Yeah.
after he was dead.
Oh yeah.
What did you do with the head?
The head I put it in that bucket, that black bucket,
Black bucket?
with the blanket on top.
Okay.
I should have away
And then where'd you leave it?
Leave the head? The head's still in the bucket. It's right by the stairs.
Just last week, a Brown County jury found Schabusiness guilty on all charges. We spoke to her defense attorney, Christopher Freilich, about the final results, the trial as a whole, and what's next for his client. Okay, so let's just start with the most recent news. Back-to-back guilty verdicts and pretty quick deliberations from the jury. What is your reaction with that?
Well, on the first phase, the jury had to decide the facts. They had to decide whether or not my client was guilty of first-degree intentional homicide, mutilation of a corpse, and third-degree sexual assault. The jury rendered its verdict. We don't necessarily agree with it, but we respect the rule of law and we respect their decision.
What do you feel about the second phase, the verdict in that half of things?
Sure. The second phase is called the responsibility phase, and the jury had the task of deciding whether Taylor Schabusiness suffered from a mental disease or a mental defect, and they found that she did not, and so the case was over at that point. We do have sentencing coming up in late September, and so we're going to gear up for that.
So what are your plans moving forward? I mean, you said you were somewhat disappointed with these back-to-back guilty verdicts. Is there any plan for an appeal in the future?
Yes, I would imagine there would be an appeal, but you can't appeal a case until the sentencing has been completed. So after the sentencing is completed, then I'm sure we'll file a notice of intent to pursue post-conviction relief, basically an appeal. But prior to the sentencing, the Department of Corrections is going to prepare a pre-sentence investigation report, a PSI, which will contain information about the facts of what happened, her background, her drug alcohol issues, prior record, family history, and things of that sort, mental health issues. And then the Department of Corrections, DOC, will make a recommendation. The defense will likely prepare a independent pre-sentence investigation report so we can provide maybe some additional information from family members and friends and other people that know her.
So what sort of additional information would you be getting from these family members and friends?
Well, sometimes the pre-sentence writer, the agent, probation agent, they don't make contact with all the family members. So that's what I'm trying to do, reach out to family members that, like maybe aunts, relatives, cousins, step-parents, people like that, grandparents. We're going to try to make contact, make a connection with them, and hopefully we can get some additional information that could be presented to the court.
Okay, so we've talked a little bit about the verdicts, and now looking ahead to sentencing. But if we go back to the start with your time on the case, you were not Schabusiness's first attorney. I mean, Quinn Jolly is the one a lot of people remember after she physically attacked him. We have that on video. And then also one of your defense experts mentioned that Schabusiness had thrown a chair at her when they were having an interview previously. So when you started, were you concerned about her being physically violent?
No, I wasn't afraid at all. Wasn't even going to go there. The concern was, her, whether she was mentally stable, whether she was competent. So we had, since my involvement, we had some competency evaluations completed. and we had an NGI evaluation done. I gathered all kinds of different records in court. I'm sure people heard about the Bellin records, the Nicolay psychiatric records, Purveyor records, jail records, lots of different documents that we gathered and reviewed. I think all of that information was helpful for the jury. I hope it was. And I think it'll be helpful for the court, when it ultimately makes a decision on what to do, what the sentence is going to be.
So when you were speaking to your client, Taylor Schabusiness, you said you weren't even concerned about her being, physical in any way. What were your conversations like early on? Because we've seen her with a wide range of emotions throughout her court appearances since the incident in 2022.
Well, I tried to, garner some trust and develop a rapport with her. And, I spent a lot of time with her, try to explain the procedure, some of the legal issues, the jury instructions, reviewed discovery, reviewed photographs. And I think that over time, I think she trusted me and believed that I was trying to help her. And so I think that hopefully played a big role in, the attorney-client relationship. I think we had a fairly good relationship there, actually a good one, a very good one. It does take time to develop that relationship because, you're new, you're coming on board, and you've got to kind of work together and go through the facts. And I believe that we were partners in, just trying to review everything and assess all of the information and all the legal issues that were involved.
So you had to have some pretty serious conversations with her about this crime that is very serious, but also things like her right to testify. I know that you mentioned in court multiple times, there was 2 different phases there, that she did not want to testify. You guys had discussed it at length. What were those conversations like? What was she saying why she did not want to testify in either phase?
I can't get into the details of all of that because it's protected by the attorney-client privilege. But, generally speaking, a lawyer will review with the client. You have a constitutional right to testify if you so choose. You also have a constitutional right not to testify. You have the right to, under the Fifth Amendment, to maintain your privilege against self-incrimination. So, those are things that we talked about. And it was talked about in court on the record. And she ultimately chose, it was her decision, not my decision. It was her decision not to testify. And that was based on a lot of different things that were presented. But I can't get into the details of that.
So let's get into the actual case itself. There's a lot of evidence in here, a lot of things to go over. But one of the things I wanted to touch on was Taylor Schabusiness's relationship with the victim, Shad Thyrion. So we heard a bit here that they had known each other since their days in middle school back in Howard Swamico, and then into high school in Bayport. I believe in one of her police videos, she even mentioned that they had dated at some point. So can you really clear up for us what their relationship was like in the past and then what it was at the time of this crime in 2022?
Sure. I think, in the past when they were in middle school, they were friends. They went to school together in the Howard Swamico Middle School. And then it moved to high school, and they both went to Bayport High School together. When they were in high school, I believe they were dating. They were in a relationship, but they were still kids. They're teenage kids, but they were sweethearts. And then I think their relationship, once they finished high school, likely, kind of subsided, or they kind of went their own separate directions. But then they reconnected later on, because there was a point in time where she was living in, I think, Cotulla, Texas, with her grandparents. I know she had her baby, and then she came back to Green Bay, and I think that they reconnected. And but at the time of the alleged incident, I don't think they were necessarily dating. They were just involved as friends. They were friends, and they had other friends as well.
Okay, so I guess I want to dig a little bit deeper in this if we can. So she had mentioned something about, in one of her police interviews, they were asking if they were having sex, and Taylor Schabusiness said it was getting there. So is this something that was maybe like a friends with benefits situation, or just a one-time thing? She referred to him as her buddy, her homie, several different times.
Yeah, I really don't know the extent of that. I do remember that comment that she made to, it was either Detective Groff or Detective Kemp, from the Green Bay Police Department. It really was unclear if they were in an actual boyfriend-girlfriend relationship. I really don't know. I know they hung out and they were friends. That's all I know.
Okay, and looking into her other relationships too, I mean, you mentioned her grandparents in Texas. We also heard testimony from her father that her baby now lives in Texas with those grandparents. So, did you get into at all the history of her child, her husband, things like that?
We got into that to some extent, not in depth. I think we will now get into that more in depth as it relates to the sentencing. Um, I have seen additional information with regards to the relationship she previously had with the baby. I've, seen lots of information with regards to that, pictures. So a lot of that will hopefully be bore out at the sentencing hearing where we can present that information to the judge, for the judge to consider the fact that this young lady had a family, had a lot of people that loved her and cared about her prior to this situation. And we'll want to present that to the court for the judge's consideration.
I think in the second phase of the trial, when you opened with the first witness being her father, that was really the first time that we saw into her childhood, into her background. Do you think that made any headway at all with the jury hearing about her mother dying at, I think it was age 11, her being moved up to Green Bay from Illinois, things like that?
I think some of that helped. I think even hearing from the father, Arturo Coronado, I think that was helpful. I think he was able to show to the jury that his daughter had, kind of a history of some mental health problems, some mental health inpatient treatment and counseling and therapy and all of that. So I think that was helpful in phase 2 of the trial.
And if we're looking at phase 1 of the trial, that's really where a lot of the prosecution's evidence laid out. So we saw some photos, we saw DNA evidence, we heard from experts, things like that. I have a couple questions about this here. One, how was your decision? How did you come to the decision of not calling any witnesses in that phase? And furthermore, how do you combat all of the overwhelming evidence that the prosecution had?
Well, the impression is that the defense didn't really call any witnesses. In fact, we did. Some of the witnesses that were on our list were called by the prosecution. So a lot of these witnesses are for both sides to tell the jury the big picture of what happened, present the facts of what happened. I know that the one witness, Scott Tomes, he was simply unavailable. Apparently, he was sick or in the hospital or whatnot, but we utilized his statement, and that portions of it was read to the jury, was presented to the jury, where the judge read it to the jury, and they could consider that information because he was certainly there on the date of the incident on February 23rd of 2022. He was at the Eastman Avenue apartment, and he saw things, he observed things, he knew things, but he simply wasn't available for the defense. And certainly as diligent defense counsel, diligent attorneys, we asked the court to consider a motion for mistrial. That was denied. And so the next best thing was to present, portions of his statement that was germane to the issues in the trial, and that's what we did.
I think another interesting part or piece of evidence, rather, that was brought up is this photo of Taylor Schabusiness with Jeffrey Dahmer. We're also seeing some Google searches in relation to him. And this is kind of interesting. I mean, you yourself brought it up. I think you made mention of something like he may be the worst serial killer in Wisconsin state history. People in this state really, hear that name and think of terrible things from back in the 90s. So when this was brought in as evidence, not all of it, I know that some of the pentagrams and things were left out, but when jurors had to hear about Jeffrey Dahmer and see this photograph, do you think that that affected them? I mean, that's a huge name in the state of Wisconsin.
Yes, everybody knows that Jeffrey Dahmer killed multiple people in the city of Milwaukee, and I agree that he is probably one of the worst serial killers in Wisconsin history, if not the entire U.S. And at least from my perspective as defense counsel, I did not believe that information was even relevant. I didn't think it should come in. I think it created a sideshow. I think it put my client in a bad light. We're not here to decide anything about Jeffrey Dahmer. We're here to decide whether or not Miss Schabusiness committed the crimes that she's charged with. We respectfully objected. I think the judge had to do the best that he could, but the judge entered his ruling, and we respect the rule of law, and we respect the judge's decision on that. But we vigorously argued against that. We did not believe that was even relevant to come in at trial.
And this kind of leads into my next question, too, a motion for change of venue. So the crime happened in Brown County in Green Bay. And I know that you were interested in maybe moving it out of Brown County based on the jury pool. I mean, a lot of jurors, even during jury selection, said that they had seen something on the news about this, they had heard about it, etc. So I guess, how did you feel when, the trial was in Brown County? Why did you make that motion to have it moved?
Well, I think, a motion for change of venue, the place of trial, or change of venire, I think that was something that a prudent lawyer would do. That's kind of a standard practice to bring that kind of a motion for the court to consider, whether or not we can get a fair and impartial jury in Brown County, or whether the judge should maybe move the trial to a different county where maybe people haven't heard about this case, or bring in jurors from another county into Brown County. So we asked the judge to consider all of that, and we provided some information as to the news feeds, the information on TV, I believe the alleged attack or the apparent attack on Mr. Jolly, and all of that. But it's the judge's decision, and at the end of the day, the judge said no. The motion is denied, and we totally respect that, but we felt it was a proper motion to bring for the court to consider.
Do you feel that she did get a fair trial in Brown County?
Yes, I do. I think the rule of law was protected and followed. I believe that she did get a fair trial. Obviously, the case will likely go up on appeal, and there'll be lots of issues for appellate counsel to consider and review, but yes, I believe she received a fair trial.
And you mentioned it previously in one of your answers, talking about the local media coverage of this case in particular. I mean, maybe since 2018 and the George Birch murder of Nicole Vanderheiden, there hasn't been so much media coverage of a murder in the area. So did you yourself follow the case before you took it on?
No, really, not really. I saw the clip of, the courtroom situation with Mr. Jolly, but not really. I had other cases to work on, so I wasn't following this case.
Oh, that's very interesting. So when you started, it was basically like a blank slate, start at square one, and then moved forward from there?
Yes, a clean slate for me. I came into it and just started right out of the gate, analyzing, getting all the materials, organizing the materials in binders, and meeting with my client.
And how many weeks, months of preparation did you have? Because I know you came on after Jolly.
Right. I think it was probably about 8 or 9 months or so. Typically, in other cases, you'd have more time, but I just picked up the ball and ran with it and did the best job that I could. I spent pretty much every single day from when I got the case, reviewing materials and analyzing things and working on the case.
In retrospect, is there anything you would have done differently?
Well, I think in every case, there's always things you could do differently. Wonder about other witnesses or other experts or things like that. But, hindsight is 20/20, and I believe that we did the best job that we could with what we had.
Schabusiness is slated to be sentenced on September 26th. Because Wisconsin doesn't have the death penalty, she now faces a sentence of life in prison without the possibility of parole. Reporting for Law&Crime Network, I'm Gillespie.